Welcome to our second segment of the World Trade Center 9/11 Zadroga Bill. We're talking with John Dearie. I'm John Dearie, John C. Dearie, John P. Dearie, and we'll continue talking on the subject now, John, of injuries, which you've mentioned in the first segment. There are malignancies, cancers, and there are non-cancers. Maybe give us a sense as to, it's a rather long list, and we're going to have it up on the screen so that viewers can see the full range of what these injuries are that are qualifying for the Zadroga program. But why don't you touch on maybe a couple of the dominant ones in each of those malignant and non-malignant categories?
When the Zadroga Bill was first signed into law in 2011 and the Victim Compensation Fund was created, pursuant to the language of the Zadroga Bill, initially the Victim Compensation Fund only covered about 15 or 16 what they call qualifying injuries and no cancers. That was just the way that the Zadroga Bill was written and signed into law. So for the first, year and a half or so of the Victim Compensation Fund, the only eligible conditions, qualifying injuries, were non-cancers. They included things like interstitial lung disease, asthma, RADS, GERD, COPD, sleep apnea, chronic rhinosinusitis, things like that. Those were the types of injuries that, as I said, initially were covered by the letter of the law of the Zadroga Bill. On around September 11th of last year, 2012, around 50 cancers were added to the overall list of covered conditions of the Victim Compensation Fund. There was a lot of public, kind of outcry and request that cancers be added to the list of qualifying injuries because medical evidence had shown that first responders who were working down there were in fact showing higher rates of cancer. So as I said, last year, right around this time, around September 11th, a list of 50 cancers was added. So now, anyone who has been, as I said earlier, who worked down at the World Trade Center site and has been diagnosed with either any of the original qualifying injuries or now any one of these 50 qualifying cancers can be eligible to submit a claim and receive compensation from the Victim Compensation Fund.
How is a person to make it clear to the Victims' Compensation Fund that, in fact, they have been diagnosed and are suffering from whatever the qualifying illness is that they claim?
By far the easiest and best way, both for the claimant and for the claimant for the purposes of their claim to the Victim Compensation Fund, is to get treated, diagnosed, and certified by the World Trade Center Health Program. As I explained earlier, the Zadroga Bill created two entities. It created the World Trade Center Health Program and it created the Victim Compensation Fund. So in some way, the VCF and the Health Program can kind of be looked at as brothers or sisters. So when a claim is submitted to the Victim Compensation Fund, one of the first things that the claim reviewers do at the VCF is they ask the World Trade Center Health Program what conditions, which of the qualifying injuries does this particular claimant have. So if a claimant has been certified through the World Trade Center Health Program, then that will automatically show the Victim Compensation Fund that they have been diagnosed with said condition and that said condition was likely caused by the claimant's exposure at the World Trade Center site. So the easiest and best way to do it, to get diagnosed and show the VCF that you have an injury, is to do so through the World Trade Center Health Program and one of its several clinics around the tri-state area.
How does a person believing that they have one of these qualifying illnesses, if they haven't already, how do they get plugged into the World Trade Center Health Program?
Well, even if a first responder doesn't think that they have one of these qualifying injuries, because oftentimes they may not think that they do, but any first responder really should reach out to and contact the World Trade Center Health Program. Their main location is located at Mount Sinai Hospital, and they have several clinics located around the 5 boroughs around the tri-state area. And even if you're outside of the tri-state area, through a medical entity called LHI, first responders can still receive free health care through the World Trade Center Health Program around the country. So that is the best way to, as I said, any first responder should really reach out to the World Trade Center Health Program for a consultation.
That really is a smart thing to do, and it probably is looked on very favorably if their illness is certified by the World Trade Center Health Program.
It is, but in some instances, it's impossible for someone to get certified by the World Trade Center Health Program. The typical example is that a first responder who has already passed away or lives outside of the country and just lives outside of the tri-state area and can't easily get to one of these clinics. So if a first responder is already deceased and while they were alive they didn't go to the World Trade Center Health Program, that does not preclude them or their estate and their family from submitting a claim to the VCF. We can still go through the process of certifying a deceased first responder's injuries to the Victim Compensation Fund by reaching out directly to their private treating physician who can fill out various forms and paperwork and ultimately make the medical determination that as this deceased first responder's treating physician, he does in fact believe that their exposure at the World Trade Center site was a contributing factor to whatever of the qualifying injuries that he may have had.
So you're really saying, absent someone who has passed away or someone who lives outside the tri-state geographic area who could get access to a Mount Sinai or one of the other facilities, basically absent that group, everyone else should be going to the World Trade Center Health.
Yeah, it certainly behooves first responders to get into the World Trade Center Health Program.
If someone begins to file and then passes away, what happens to that person's claim?
It kind of depends on what part of the claims process that claim is at. If the claim has already been submitted in full, if the eligibility form has been submitted and the compensation form has been submitted, and then a first responder passes away, the claim can likely continue under the name of the now deceased person. If the claim is at the early stages or kind of in the middle, and the first responder, the claimant, passes away, likely what will be the easiest and best course of action is to actually kind of start from the beginning as a deceased claim. So as opposed to having all of the authorizations signed by the first responder themselves, we're now going to have authorizations signed by next of kin, in most cases the decedent's wife, who is now going to act as a personal representative for the purposes of the Victim Compensation Fund to essentially usher their husband or their wife's claim through the claims process as their personal representative.
Is it necessary for that surviving spouse to file in their local surrogate's court and get designated as, for example, an administratrix or to be appointed through a will? Or is that something that they can just indicate that they are the spouse and just file accordingly?
It is significantly easier if the surviving spouse has been appointed as administrator or administratrix of their deceased spouse's estate. It makes the claims process significantly easier. There is a way, if for one reason or another the surviving spouse has not been appointed administrator of their deceased spouse's estate, if for one reason or another that can't happen or hasn't happened, or it'd be very onerous on the surviving spouse to do that, there is a way to usher the claim through the process. But again, if at all possible, it makes the claims process much easier.
John, what would you describe the role of the special master? What role does she have in terms of the administration of the Victims' Compensation Fund?
The special master, by the name of Sheila Birnbaum, was appointed to be the administrator, the overseer, the chief executive of the Victim Compensation Fund. She's essentially the CEO of the fund. She makes policy decisions as to how the fund will operate, how they will review claims, really overall, as I said, policy decisions, and it's her fund. She's the head honcho at the VCF.
There was a lawsuit here in the years prior to the Zadroga, '06 to '09 or 10 in there. Very substantial. I think it was somewhere like $800 million was the ultimate settlement. The city, Port Authority, and others, contractors were involved as defendants. If someone was part of that lawsuit, are they still eligible to be able to file for the Zadroga?
Yes, they are still eligible to file for the Victim Compensation Fund. However, if they received any settlement dollars from the lawsuit, that money, that settlement amount, would be considered a collateral offset that we discussed earlier. So if a claimant to the Victim Compensation Fund received $15,000 from the lawsuit, and at the end of the day, as a result of their claim to the Victim Compensation Fund, they are awarded $30,000, $15,000 is going to get deducted, and ultimately they will be left with a $15,000 award from the Victim Compensation Fund.
Talking about awards, suppose someone, for example, got $100,000, to keep the numbers round, $100,000 in an award under the lawsuit. Now, under the Zadroga, in order for them to benefit and get any funding, their award has to exceed $100,000. Is that correct? Because what they received in the lawsuit is in effect a collateral source that's an offset against whatever it is that the Zadroga award may offer them.
Yeah, that's right. So any amount that a claimant to the VCF received from the lawsuit, ultimately, in order to recover any money from the Victim Compensation Fund, their award will have to be in excess of whatever settlement amount they received. If it's not, if a claimant received $50,000 from the lawsuit and ultimately receives a $40,000 award offer from the Victim Compensation Fund, they ultimately will not receive any compensation from the VCF.
If a person gets an offer for settlement from the Victims' Compensation Fund, is that final or can that be appealed?
There is an appeals process. In order to make an appeal, the claimant and the claimant's attorney has to specify the reason for the appeal. Are we appealing on the grounds that, for example, the non-economic loss calculation of the award was not high enough or was not sufficient? Does the non-economic award not, in the claimant's opinion, sufficiently compensate them for the pain and suffering that they have endured as a result of their eligible conditions, or the loss of enjoyment of life? Does the non-economic award not properly compensate them for that? In the alternative, does the economic award not properly compensate them? For one reason or another, did the Victim Compensation Fund not consider the 6 months of work that the claimant missed and was not paid for while they were going through chemotherapy, for example? Or finally, has, in the process of submitting the claim, has the claimant now been diagnosed with an additional qualifying injury or an additional cancer? So let's say that we started the claims process and the claimant had asthma and COPD. In the course of the claim being evaluated by the Victim Compensation Fund, if the claimant was then diagnosed with, let's say, lung cancer, they now have an additional significant injury that was not considered by the Victim Compensation Fund when they were calculating their award. So in that case, we could appeal on the grounds that not all of the claimant's qualifying injuries were in fact considered by the Victim Compensation Fund.
John, thanks very much. I would say to those of you who have been watching, hope you found this to be informative, and we will now have, for several minutes, the full range of both qualifying that are malignancies or cancers, and also non-malignancies will be up on the screen so that you can see them and understand what is included as a qualifying. John, just one quick final. If someone wants to get a hold of you, what is the best way to do it, or two ways?
The best two ways, I guess, would be calling me at 212-980-0404, or perhaps even easier, email me at jpd@johndearie.com.
Thanks, John, and thanks for watching.